The pressure for the rule of law to take its course once again comes to the fore in this current administration, with the Attorney General of the Federation, Abubakar Malami's role in the discharge of justice featuring more prominently in this dispensation in a quite unprecedented frequency. While his office as the Attorney General of the Federation naturally bestows on him a leading role in the nation's anti-graft war, many of his graft hunts has been accused in some quarters has been politically motivated and sometimes selective. It's question time. Welcome to the program. I'm Benga Ashiru. You may also join in this conversation by sending us your comments on our various social media platforms showing on your screen. Is the Attorney General acting within the confines of his statutory mandate or merely using his instrument of office as a political witch hunt? Many observers in this dispensation sees the Minister of Justice as a major power broker who wields enormous influence in an intense power play in a crucial government policies ranging from the legal battle against the Senate leadership over forgery allegation, false declaration of assets, loan recovery, campaign of repatriation of stolen funds, Kogi State Assembly closure, and MTN's fine reduction, just to mention a few. Channel's television crew caught up with the Chief Law Officer as we try to put things into proper perspective. Join us in this exclusive interview with the Attorney General of the Federation and Minister of Justice, Abubakar Malami. Honorable Attorney General of the Federation and Minister of Justice, Abubakar Malami, thank you for joining us on this episode of Question Time.
Thank you, Mr. Benga.
Now, let's start by having a clear understanding of this administration's thrust for judicial reform.
The thrust of this administration judicial reform is based on 2 or 3 pillars. One, to ensure that proper legislations are in place to ensure expeditious determination of cases. That gave rise to the coming into being of Administration of Criminal Justice Act, which fundamentally has taken into account the prevailing delays as it relates to the prosecution of cases, and indeed brought about those issues and remedies that will now eliminate delays and ensure that cases are treated with dispatch. In the process of prosecution of the cases as well, we come to realize that some of these cases were not properly investigated. And then arising from the absence of proper investigation of the cases, you are bound to have delays because in the course of proceedings, multiple applications for amendments might come into play. Series of requests for further investigations may come into play, and all these things are not good enough in ensuring the expeditious determination of cases.
Could this delay be as a result of compromise on the part of the judges as reported in some quarters? And what are you doing about these cases of compromise?
The issue of prosecution of cases is a kind of tripartite arrangement in respect of which there are 3 key players. The 3 key players are 1, the investigation process, which include the police, the EFCC and associated things, and then 2, the lawyers that eventually now prosecute the cases in court, and then eventually the courts in their own right. So when it comes to issue of compromises, you cannot pinpoint one particular institution among the 3 and come to a clear conclusion that the compromises has to do with that institution.
Are you suggesting the EFCC could also be culpable in this anti-corruption trail?
No, what I'm saying is you cannot rule out any possibility because in whatever institution you look into, there are good and there are bad aspects of it. So it is not institutional as such, but then because individuals are the people that carry out the function, I mean the function of investigation, the function of prosecution, and then the function of judicial processes. So such individuals that are responsible along the line could be responsible, so you cannot institutionalize it by way of pinpointing a particular institution as being responsible. So it is something that can be a possibility having regards to the personalities or individuals involved and not necessarily the institutions that are saddled with the responsibility in respect of each and every peculiar case.
Could you clear the air? We have a report that the Ministry of Justice and the EFCC is at loggerheads in some decisions in this anti-corruption war.
No. As far as Federal Ministry of Justice is concerned and the EFCC, there is nothing like running battle. It is even out of contemplation. Why? Because EFCC is an agency under the Federal Ministry of Justice and receives directives substantially and instructions from it. So, and then they are all working hand in gloves towards the realization that things are done within the confines and the context of the law. So where does the issue of running battle arises? Since you are working for a common purpose, the two are working for a common purpose, and one is answerable to the other, and then the EFCC works in line with the dictates and directives of Federal Ministry of Justice. So I cannot understand how the issue of running battle arises in the circumstances of a superior officer and a subordinate officer, or an institution, a parastatal working under the other. It's a matter of clear understanding of roles, clear understanding of directives, and then clear understanding of a purpose for which the two are supposed to work in terms of arriving at a common destination, which destination is that of justice, fairness, and compliance with the rules of law.
Are you satisfied with the EFCC's chairman handling of investigation? Could you pass a vote of confidence on him?
Well, honestly, I have no reservations because it is a matter of working together, and in that respect, we work together, and then where there are needs for improvement, where there are needs for institutional collaborations, institutional support, we come together, we work together and ensure that things are done in accordance with the provisions of the law as it obtains in respect of each and every particular case at hand. So honestly, I think I'm comfortable to the extent that things are done within the confines of the law without reservations.
I'm sure you must have seen in the social media reports about top government officials having a difference of opinion with the EFCC over the way it has handled some investigations, which also includes Sahara Energy. Your office as the Honorable Attorney General of the Federation has also been mentioned among those that are not satisfied with the way this investigation is being handled. Could you put things in the proper perspective?
The fundamental consideration arising from the two is whether there exist reasonable grounds for suspicion of a commission of an offense. And we have no exception as far as the companies or individuals are concerned when the issues of prosecution comes into play. So honestly, I don't think there has been any misunderstanding, any unhealthy development arising from that. Whether Sahara, whether Atlantic Energy, whether individuals, whether personalities, whoever is involved, I don't think we have any cause whatsoever to relent as far as the issue of investigation, prosecution, and associated things are concerned. We are in no way under any apprehension, under any misapprehension as to what to do at any point in time and how to do it. So I don't think that we have any scapegoat as far as prosecution, investigation, and associated judicial proceedings of cases are concerned.
Now let's review the proposed draft document on special court by the Presidential Anti-Corruption Committee. Wouldn't this be passing through the National Assembly?
Well, it depends on the way and manner you are looking at it, or you are looking at the possibility of having it in place. But the conventional practice for the courts is that the courts have, the heads of courts naturally are vested with the powers to establish divisions within the existing structure of courts. If we are looking at it from the point of establishment of divisions, special divisions for the conduct of corruption cases, the need and demand for legislative process is not there at all. But if we are looking at it from the point of having in place specialized courts, just like we have higher courts, we have courts that we have to, that are expected to be constitutionally enshrined, then that calls for legislative process. I think for now, the idea of having a legislative process is not an immediate possibility, and the idea of dealing with it as an administrative process of having divisions within the existing structure might suffice the need of the anti-corruption cases.
You may also join in this conversation by sending us your comments on our various social media platforms showing on your screen. Coming up on Question Time, how does the federal government intend to deal with the culture of impunity? Find out from the Attorney General of the Federation and Minister of Justice after the break.